Good morning, everyone. Today we are going to discuss the Indian Penal Code 1860. This is just going to be an introduction. We would look at the sections and the relevant definitions for an easy understanding. Let's understand what is a crime, because Indian Penal Code is generally connected with the punishments for crime. So let's look at it in a gentler manner, in an easier manner. So what is a crime? A crime is an act which is punishable by law as forbidden by the statute, and acts also change from person to person and from country to country. This is something that we need to understand, whose definition is very relevant. We could take the definition of Mr. Blackstone. Crime is an act done in violation of public rights and duties. According to Stephen, a crime is a violation of right considered in reference to the evil tendency of such violation as regards to the community at large. It affects not just one person but the community too. So that factor also is considered. What is it that defines a crime in the Indian Penal Code? We have to definitely go by the definition of section 40 of Indian Penal Code. We have to see that there are a lot of essentials or elements of crime which have been described. Let's look at them in detail. The main elements of crime are the human being himself who has committed the crime, who is under legal obligation, and also the crime that is done by him. The second point would be mens rea, or the criminal intention of that person. Third point would be the act committed or omitted in accordance of the intention. The fourth point is the injury caused, not to just one man or the society. That is something that we have to analyze. Please remember that motive is not an essential of crime. Let's also look at the exceptions of these elements. Some offenses have not got all these essentials that we just discussed. So what are those? Bigamy, okay, which is as per section 494 IPC. Then public nuisance, which is section 268. Contempt of court. Then you have abduction, kidnapping. Then you have crimes in which injury is not essential. Here we have to look at the 3 points, which is attempt. Then you have abetment, you have criminal conspiracy. Crimes in which neither the act nor injury is essential and which will be considered as serious crimes. What are those? We will go through them section wise. According to section 399, making preparation to commit dacoity. Section 400 says punishment for belonging to a gang of dacoits. Section 401 says punishment for belonging to a gang of thieves. Section 402 states assembling for purpose of committing dacoity. So these are factors that one needs to consider. Let's also look at vicarious liability. Generally, a person is criminally liable for his own acts, but there are some exceptions in which a person is liable for the act of other persons or other people. This is exactly known as vicarious liability. Now, let's also look at the sections relevant to these. Section 154 states that owner or occupier of land on which an unlawful assembly has happened is also to be held responsible for the act. Then section 155 states liability of a person for whose benefit the riot is committed. He is also held liable. Then section 156 says liability of agent of owner or occupier for whose benefit the riot is caused. So that person also becomes liable. Now let's also look at the protection available to the accused, which is really important from the right way of dealing with law. Doctrine of double jeopardy. According to Indian Constitution, Article 20.2 states, no person shall be prosecuted and punished for the same offense more than once. It's called double jeopardy. There is a famous movie called Double Jeopardy, which though is not as per the Indian laws, it would be a good one if we could watch. It also states in section 300 of Code of Criminal Procedure that there is a reference to double jeopardy. Then doctrine of self-incrimination. This is according to the Constitution of India, Article 20.3. Here we have a statement which says, no person accused of any offense shall be compelled to be a witness against himself. Then we also have the Code of Criminal Procedure, which provides some protection against self-incrimination. Again, this would be, the accused shall not render himself liable to punishment by refusing to answer such questions or by giving false answer to them. This is section 313.3. According to section 315.1b, failure to give evidence shall not be made the subject of any comment by any of the parties or the court, or give rise to any presumption against himself or any person charged together with him at the same trial. You also have section 164, which states the right to legal aid, which is very important, especially for the poorest of the poor. Right to legal aid is provided by the Constitution of India. Article 39A states, according to this, the state shall secure the operation of the legal system which provides justice on the basis of equal opportunity, and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice shall not be denied to any citizen by reason of economic or other disabilities. So here I would say that everyone is taken care of if we apply the legal rules effectively. Right to legal aid is also provided according to section 304 of Code of Criminal Procedure. Now, why does this happen? We have to also look at the points of presumption of innocence. It's provided according to section 101 of Indian Evidence Act. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that these facts exist. Clearly, a man is presumed to be innocent till he is proved guilty. Then you have protection against illegal arrest, which would be according to Article 22.2 Constitution of India. No person who is arrested shall be detained in custody without being informed as soon as he may be of the grounds of arrest, nor shall he be denied the right to consult a legal practitioner or a lawyer. Protection against illegal detention. According to Article 22.2 Constitution of India, a person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the magistrate's court. Now, let's also look at section 57 of Code of Criminal Procedure. A person arrested not to be detained for more than 24 hours. Person arrested should be informed of the grounds of arrest. According to section 50 of Code of Criminal Procedure, every police officer or other persons arresting any person without warrant shall forthwith communicate to him the full particulars of the offense for which he is arrested or grounds for such arrest. When a police officer arrests without a warrant, it can happen that he is arrested without a warrant. Any person or person accused of a non-bailable offense, he shall inform the person arrested that he has the chance to be released on bail, and there should also be a medical examination of the arrested person. So this is as per section 54 Code of Criminal Procedure. Now, I guess this is just an introduction. This will give you a layman kind of idea of the sections of introductory sections of the Indian Penal Code, which will help us in our daily life. Thank you very much.